Some academics argue that the law of neutrality has come under threat due to developments in the 20th century as the end of war as an instrument of national policy, the rediscovery of collective security, an unprecedented pace of economic interdependence present a formidable jurisprudential challenge to an institution that derives its meaning from the classical polarization of war and peace and a sovereign right to wage war or to stay aloof from the wars of other states. The UN Charter and the collective security system changed the notion that a state can choose to enter an armed conflict or stay neutral. As under its Chapter 7 powers, the Security Council may take enforcement action to maintain or restore international peace and security. Member states are obliged to provide assistance to the Security Council to this end and may be required to support such an action with their armed forces. This goes against the component of impartiality inherent in the law of neutrality. Recent state practice has also moved away from traditional notions of neutrality to a status of non-belligerency or qualified neutrality, under which states still do not actively participate in hostilities. However, they may not fully comply with the law of neutrality. For instance, Italy claimed a position of non-belligerency during the 2003 conflict between the US and coalition forces in Iraq, despite having belligerent bases on its territory. States argue in favor of non-belligerency rather than neutrality for a number of reasons, including that they reserve the right to favor the victim of aggression over the aggressor. Moreover, if they face a threat from a belligerent state, they should not be expected to treat that state impartially. Given the advent of the collective security regime, globalization, which has increased states' interconnectedness, as well as changing notions of neutrality to that of non-belligerency, the law of neutrality may see more changes in the future. It may be that the future law of neutrality is somewhat circumscribed in the ways in which a state may violate its neutral status, in that providing assistance to the victim of aggression may no longer compromise its neutrality.